I was desperate. They thought 23 years of silence had made me soft, made me grateful enough to share what wasn't theirs to begin with. When my biological mother walked into that courtroom in her pressed blazer and her careful smile, she looked at me like I was still 7 years old. Still small enough to dismiss. She had no idea what I was holding. My name is Wren Calloway. I'm 31 years old, and for most of my life I've had two origin stories. The one that's true, and the one I used to tell at sleepovers when I was 12 because the truth was too heavy to carry into someone else's house. The true one starts on a Tuesday in October. I know it was a Tuesday because my kindergarten teacher, Mrs. Albright, always did arts and crafts on Tuesdays, and I remember being upset that morning because I'd wanted to finish the paper turkey I'd started the week before. I told my mother that on the drive to the bus station in Columbus, Ohio. I said, I didn't get to finish my turkey. She said, you can make another one. She was already thinking about how to leave me there. I was 7, not 5. I want to be precise about that because precision matters when you're telling the story of your own abandonment. 7 years old, second grade, 42 pounds, wearing a green corduroy jacket my mother had bought at a Goodwill 2 weeks before. I remember that jacket because I wore it for the next 4 years, long after the sleeves stopped reaching my wrists, because it was the last thing she ever gave me. The Greyhound station on South High Street smelled like diesel and old coffee and something sweet underneath that I could never identify. My mother told me to sit on a bench near the women's restroom. She said she was going to the ticket counter. She said she'd be right back. She had a rolling suitcase with her, the kind with the broken wheel that dragged sideways, and I watched it scrape across the floor until she rounded the corner near the vending machines. I waited 45 minutes before I understood she wasn't coming back. I didn't cry right away. That surprises people when I tell them that. But I was a practical child in the way that children who've been through a lot sometimes become practical very early. I understood, somewhere in the part of my brain that processed facts before feelings, that crying wasn't going to fix what had just happened. I sat on that bench for 45 minutes watching people come and go, and then I walked to the information window and told the woman behind the glass that I thought my mom had left without me. Her name was Eunice. I never forgot that either. She had reading glasses pushed up on her forehead and a Columbus Clippers coffee mug that was chipped on one side, and she looked at me for a long moment before she picked up her phone and called someone. The someone she called was a man named Arthur Voss. Arthur worked for the transit authority at the time, some kind of liaison role between the station and the city, and he was the one who came and sat beside me on that bench while Eunice called the police. He didn't ask me 100 questions. He didn't talk to me like I was broken. He bought me a bag of Fritos from the vending machine and sat with me and asked if I wanted to watch him do the crossword puzzle while we waited. He was 64 years old, widowed, wore bifocals and a watch that was 30 years out of date, and I thought he was the safest feeling person I had ever been near. The police came. Child Protective Services came. There were forms and questions and a woman with a lanyard who took me to a group home in Worthington that night. I held the green jacket in my lap the entire ride. Arthur followed up the next day. And the day after that. The system is slow. I need you to understand that because it matters for everything that comes later. I spent 14 months in 3 different foster placements before Arthur Voss became my legal guardian, and another 11 months after that before the adoption was finalized. 25 months total. There are records of every single month. Case notes, court dates, home visits, school transfers, medical appointments. The state of Ohio does not lose paperwork on abandoned children. That paperwork exists. All of it. I'm telling you this now because my biological mother's lawyer later tried to argue that the timeline was murky. It was not murky. It was documented in triplicate and signed by a family court judge. Arthur's house was a brick ranch on Ferris Avenue in Hilliard, 15 minutes west of Columbus. It had a backyard with a crabapple tree and a garage he'd converted into a workshop where he built birdhouses on weekends. He drove a 2003 Ford F-150 that smelled like sawdust. He made oatmeal every morning and kept exactly one flavor of ice cream in the freezer at all times, butter pecan, because he said the world became unnecessarily complicated when you offered too many options. He never tried to be my father in the showy, performative way I'd seen in movies. He just showed up. Every parent-teacher conference, every dentist appointment, every single Saturday morning soccer game where I spent most of my time picking dandelions in the outfield because I had no athletic instinct whatsoever. He was just there. Quietly, consistently, completely there. I asked him once, when I was about 14, why he'd kept following up after that first day at the bus station. We were in the workshop, and he was sanding the roof of a birdhouse, and he was quiet for long enough that I thought he hadn't heard me. Then he said, because someone needed to. That was Arthur. I graduated from Ohio State in 2015 with a degree in accounting. Arthur drove to every single ceremony, undergraduate, then the CPA exam results, then the firm job offer, in that same F-150, which by then had 212,000 miles on it and a crack in the windshield he refused to fix because the crack was, in his words, structurally irrelevant. I got a job at an accounting firm in downtown Columbus. I rented an apartment in Grandview Heights. I visited Arthur every Sunday for dinner. He was diagnosed with pancreatic cancer in March of 2022. He died 11 months later in February of 2023. I'm not going to try to describe those 11 months in a way that does them justice because I can't. Some things don't compress into words without losing their shape entirely. What I will say is that I spent as much of that time with him as I possibly could, and that he spent most of it in his workshop building birdhouses. Because that was what he wanted to do with whatever time he had left. And I sat in the corner on an overturned milk crate and handed him sandpaper, and sometimes we talked and sometimes we didn't. He left me everything. I didn't know the everything was as large as it was. That's the part that still catches me sideways when I think about it. Arthur Voss, who drove a dented F-150 and bought store-brand oatmeal and never once mentioned money unless it was to remind me to max out my 401k contributions, had spent 40 years quietly investing. Index funds, mostly. Some real estate he'd sold in the late 90s and reinvested. A life insurance policy from his first job that he kept paying into for decades. The birdhouses he sold on Etsy for $22 each, which I used to tease him about and which he took completely seriously. The estate totaled $4.8 million. I found out from his attorney, a woman named Deborah Finch, who called me 6 weeks after the funeral and asked me to come to her office. I sat across from her desk and she read me the will, and I didn't fully process the number until she said it a second time. $4.8 million. To Wren Calloway Voss, his adopted daughter. Everything. I drove home and sat in my car in the parking garage for 20 minutes before I could make my legs work. The letter arrived 8 weeks later. It was from a law firm in Cincinnati I'd never heard of, Hartley and Brunet, and it was addressed to me by my birth name, a name I hadn't used in over 20 years, a name I hadn't heard spoken aloud since a social worker said it at a court hearing when I was 9 years old. Seeing it printed on formal letterhead felt like someone had reached through time and grabbed my wrist. The letter informed me that my biological mother and biological father, who had, apparently, stayed together or reconnected at some point in the intervening 2 decades, I genuinely didn't know which, and it didn't matter, were contesting Arthur's estate. Their legal theory, as best as I could understand it from the 3-page letter, was that Arthur had suffered from diminished mental capacity in the final year of his life and had been unduly influenced in the drafting of his will. They claimed that as my birth parents, they had standing to bring this action on my behalf as a protective measure. A protective measure. I read that phrase 4 times. Their claim was, in plain language, that Arthur hadn't been of sound mind when he left his money to me, and that therefore the will should be invalidated, and that therefore the estate should pass through some alternative legal channel that would somehow benefit them. It was legally thin in the way that bad arguments sometimes dress themselves up in formal language and hope nobody looks too closely. I called Deborah Finch that same afternoon. She was quiet for a moment after I finished reading her the relevant sections. Then she said, they need to establish standing first, and that's going to be difficult for them. But get me that letter today. I drove to her office and handed her the letter, and she made a copy and handed the original back and looked at me over her reading glasses and said, "Do you want to fight this?" I said yes before she'd finished the sentence. The next 6 months were not glamorous. People who haven't been through litigation sometimes imagine it as a series of dramatic courtroom moments. People standing up and making speeches, revelations at key intervals, everything building toward a climax. The reality is mostly paperwork and waiting and phone calls from your attorney that start with, "So there's been a development," in a tone that requires you to sit down before you hear the rest. My biological parents' attorney, a man named Greer who wore the kind of suits that announce themselves, filed a motion to challenge the validity of the will based on undue influence and lack of testamentary capacity. To support this, they needed to show that Arthur had been cognitively impaired and that I had somehow manipulated him. Deborah requested Arthur's complete medical records. His oncologist testified via deposition. His cognitive assessments, which had been conducted routinely throughout his illness, showed no impairment. His last will and testament had been drafted 18 months before he died, when he was ambulatory and sharp and had, according to Deborah, more testamentary capacity than most people who walk into an attorney's office. His attorney at the time had noted that specifically. Then there was the matter of standing. My biological parents' connection to me had been legally severed when the adoption was finalized in 1993. Their argument that they had standing to act on my behalf required them to establish some ongoing legal or familial relationship with me that simply did not exist. Deborah filed a motion to dismiss for lack of standing. It was, she told me, the strongest motion she'd filed in 11 years of estate law. Greer's response was to argue that the adoption had been procedurally flawed, that the records were incomplete, that the chain of custody between the bus station and Arthur's guardianship was unclear. This is where the 25 months of documented foster care history became, to use Deborah's word, decisive. The Columbus Police Department had a report from October 1992. The Greyhound station had security records. Franklin County Children's Services had a complete file. Arthur's initial guardian application, his home study, every court date, every signed order, all of it was preserved and produced in discovery. There was no gap. There was no procedural flaw. There was a paper trail so thorough and so continuous that Greer's argument didn't just fail, it failed in a way that was visible from a distance. The judge, a woman named the Honorable Patricia May 9, whom I will remember for the rest of my life, granted Deborah's motion to dismiss with prejudice. That means they couldn't bring the same claim again. She also awarded attorney's fees, meaning my biological parents would be responsible for a portion of my legal costs. She noted in her written opinion that the motion had been without merit in law or fact. I was sitting in the second row of the gallery when the clerk read the ruling into the record. My biological mother was at the plaintiff's table. She had worn the pressed blazer again. She had that careful smile again, the one that was meant to look confident. When the clerk finished reading, she didn't look confident anymore. She looked at the table in front of her. Greer leaned over and said something in her ear and she didn't respond. I didn't feel triumphant. I want to be honest about that because the triumphant version would be cleaner and easier to tell. What I actually felt was tired and then, a few minutes later, something quieter. Something that felt less like winning and more like the end of a very long wait. I walked out of the courthouse into a February afternoon. The sky was that pale, washed-out blue that Columbus gets in winter, and the air smelled like cold concrete and car exhaust, and there was a parking meter on the corner that was blinking like it couldn't decide whether it was expired or not. I stood on the sidewalk and I called Arthur's cell phone, which I still hadn't deleted from my contacts, because that's the kind of irrational thing grief makes you do, and obviously it went to voicemail, and his voice said, "You've reached Art, leave a message." And I stood there on the sidewalk in February and said, "We won." And I put butter pecan in the freezer. Then I walked to my car. I get asked sometimes by people who know the story whether I ever felt anything toward my biological parents, whether there was some part of me that wanted to understand or forgive or find some explanation that made the bus station make sense. I'll be honest, I tried, for a few years when I was in my 20s, to locate that part of myself. I read things about trauma and family systems and intergenerational poverty, and I genuinely tried to hold space, as the phrase goes, for something more complicated than anger. What I found, when I looked honestly, was that the answer was not particularly dramatic. I didn't hate them. I also didn't need them to make sense. Arthur had given me something that made their absence not just survivable, but eventually irrelevant. Not wealth, though that turned out to be part of it, but the simpler and more fundamental thing of being reliably present, of being someone who showed up. The lawsuit didn't change that arithmetic. It tried to, I think. I think part of what they wanted, beyond the money, was for me to feel like I owed them an accounting of my life, like their absence entitled them to some portion of what I'd built in the space they'd left. It doesn't work that way. You don't get to abandon someone and then claim equity in what they became without you. Arthur's birdhouses are still in the workshop on Ferris Avenue. I own the house now. I kept the F-150 too, even though the crack in the windshield has gotten slightly less structurally irrelevant with time. I have his watch on my wrist, the outdated one, and I have his oatmeal recipe, which is not a recipe so much as it is oatmeal, water, a reasonable amount of time. And I have the letter, the one from Hartley and Brunet, in a folder in my filing cabinet, not because I need to remember what happened, but because some documents deserve to be kept, the ones that mark the exact moment someone underestimated you and lost. I've thought a lot about cause and effect since that February afternoon outside the courthouse. Not in any abstract philosophical way, just the plain, practical kind of cause and effect that you can trace with your finger like a line on a map. This happened, and then that happened, and then that happened. The chain is long, and it starts at a bus station in Columbus with a woman dragging a suitcase with a broken wheel, and it ends, if it ends anywhere, with me standing on a sidewalk talking to a voicemail. What my birth parents did that Tuesday morning had consequences they couldn't have predicted because they weren't thinking that far ahead. People who abandon a 7-year-old at a Greyhound station aren't running long calculations. They were thinking about themselves, about whatever it was they needed that didn't include me, and they left. That decision set everything else in motion. It brought me to that bench. It brought Eunice to her phone. It brought Arthur to sit beside me with a bag of Fritos and a crossword puzzle, and it brought 25 months of documented foster care history into existence. History that, 30 years later, a judge in Franklin County would describe as decisive. They created the very record that defeated them. I find that worth sitting with. Arthur used to say that the way you treat the small moments is the way you treat everything. He wasn't talking about grand gestures. He was talking about showing up to a soccer game where your kid spends most of her time picking dandelions. He was talking about following up on a child at a bus station when nobody asked him to, when it wasn't his job, when there was no reward in it for him. He did it because someone needed to, and that phrase, so short, so plain, is maybe the most complete moral philosophy I've ever encountered. Not because it's complicated, but because it isn't. It asks only one question. Is there someone who needs something that I'm able to give? And then it asks you to give it. I think about what it takes to live that way. It takes something I'd call character, though I'm aware that word can sound hollow. What I mean by it is the specific kind of integrity that holds its shape when no one is watching and there's nothing to gain. Arthur had it. He had it in the workshop and at the soccer field and in the oncologist's office when he was the one who needed things and still somehow managed to make sure I was okay. That's not circumstance. That's a person who built themselves over decades into someone worth being. The lawsuit taught me something too, something I didn't expect to learn from it. It taught me that intelligence without honesty is just a more sophisticated way of failing. My birth parents and their attorney built an argument that was clever in its construction and empty at its foundation, and the emptiness was always going to show. You can dress a bad claim in good language, but you cannot make it true, and the truth in this case was sitting in a filing cabinet at Franklin County Children's Services, patient as anything, waiting to be asked for. I also learned that resilience isn't something you perform. It's not the absence of falling apart. I fell apart plenty. In the parking garage, on the phone with a voicemail, in the workshop handing Arthur sandpaper while I understood that there wasn't much time left. Resilience is just the decision, made quietly and repeatedly, to keep going anyway, to drive to the attorney's office, to say yes before she finishes the sentence, to put butter pecan in the freezer for someone who isn't there to eat it, because the gesture still means something even when no one sees it. I'm 31 years old. I own a brick ranch on Ferris Avenue with a crabapple tree in the back and birdhouses in the workshop. I have a cracked windshield. I keep meaning to fix. Some things, it turns out, you inherit not in spite of someone, but because of exactly who they were. And that's the kind of inheritance no one can contest.